Okay, good morning. I am Heather Wire with the Washington State Healthcare Authority, and this webinar is being recorded. A copy of the recording will be sent out in about a week or two to all those who are registered for the webinar. As I said, Shalia is unexpectedly out, so please bear with me if any technical issues should arise. Trying to do the technical side and also host here. So before we begin, I would like to do a quick poll to find out how many First Steps MSS and or ICM providers are participating. So I'm going to launch the poll now. So if you could just answer yes if you're a First Steps MSS and ICM provider or supervisor, or no if you're not. This webinar is open to everyone. We just kind of like to get a sense as to how many of the participants are First Steps providers or work within the First Steps programs. Couple more seconds. It looks like most of the answers. I'm close to all. Five more seconds. I'm going to end the poll. So 70% of you are First Steps MSS and ICM providers, and 30 are not. So welcome to everyone who is here this morning. And I hope that the poll is gone and you're now seeing my screen. We have a packed agenda today, so we will try to answer as many questions as time allows. So please enter any questions that you have during the webinar in the Q&A field. And if we're unable to get to some of the questions, we will put together an FAQ that will be sent out in the email with the recording. So this is the agenda for today. We have some wonderful presenters who are going to be talking about pregnant workers' accommodation rights in Washington. And then we'll do some program updates and reminders, answer any questions, and do a wrap up. So I'd like to welcome Alma Paletti, who is the Investigations Manager for the Civil Rights Division since 2017. She supervises the work of investigators assigned to the Civil Rights Division, CRD. A little bit about their office. The Attorney General's Wing Loop Civil Rights Division, or CRD, investigates discrimination in a range of areas, including in employment, housing, education, credit, and insurance transactions, and at government offices and businesses that are open to the public. The Civil Rights Division works closely with the Attorney General's Consumer Protection Division and the Washington State Human Rights Commission. Alma previously worked as an investigator for the U.S. Department of State and as program coordinator for the United States Agency for International Development. She has her bachelor's in laws from her native country, Paraguay. Terry Healy is our other presenter and is an Assistant Attorney General for the Civil Rights Division since November 2022. Began her career at the San Francisco office of the Equal Employment Opportunity Commission, EEOC, in October 2000 as an administrative judge. In 2003, she joined the Seattle office of the EEOC, where she worked as a trial attorney for 20 years. In addition to her role as a trial attorney, Ms. Healy served as a mediator for federal sector EEO cases, served as an attorney advisor to the chair of the commission, sat on the advisory committee for the chair of Bureau's Artificial Intelligence Initiative, and Vice Chair Samuel's postdoc work group. So welcome. I'm going to turn off my camera as I'm getting messages that my internet's a little unstable. So hopefully you guys were able to hear that. And I'm going to stop sharing so that our wonderful speakers will be able to share their screen.
Can someone tell me, is it working? Can you see the PowerPoint? Okay, great.
Yes.
All right, here we go. This is our, thanks for the introduction. My name is Terry, and Alma and I work with the Wingloot Civil Rights Division. As you heard, it was created by attorney Bob Ferguson in 2015 with the idea of having an office that is affirmatively protecting the civil rights of folks in Washington. While it was a one-person shop originally, there's now 15 practicing attorneys, 3 investigators, and 6 professional staff. And the mission is to defend and advance the civil rights of all people in Washington through collaboration, advocacy, and enforcement. And as you heard before, we have a variety of different types of civil rights that we enforce: discrimination in a variety of areas, which is employment, housing, education, credit transactions, insurance, and a variety of different places, government offices, or just public businesses. So I am going to try and do a very brief overview of what, the civil rights laws. So we'll see how this goes. I wanted to tell you that we should be proud in Washington State because we enacted our discrimination statute 15 years before the Civil Rights Act of 1964 was enacted. And under the Washington law against discrimination, I'll put Title VII up here too. So the federal law was enacted in 1964 and Washington law in 1949. Under both laws, it includes pregnancy discrimination as part of sex discrimination. So it wasn't explicit in either of these laws, but did cover whether or not the employer could discriminate against a woman because they were pregnant or decided to have a baby. What that meant was the employer couldn't make any policies that negatively affected one sex over the other unless they could prove that the policy was necessary for the operation of their business. But like any law that's not explicit, you don't see pregnancy in either of these. There were a lot of court cases on exactly when treating a pregnant woman differently was in fact because of sex. And this came up in cases dealing with examples of treating both genders the same, like in the context of short-term disability. Both of the sexes were treated the same. However, pregnant women weren't treated the same as the subclass. So what Congress did was go ahead and enact a law that made it very explicit that pregnancy is in fact a protected category, and that came with the Pregnancy Discrimination Act. And what that said is that pregnant women are able to work and must be permitted to work in the same conditions that we would expect for others. And they have to be accorded the same rights. So the same rights as others who are disabled from working. So they made it clear this is definitely a protected category, and that was in 1978 when that was enacted. And let me go back. One thing that I wanted just to point out, and I think is super important, is that under all of these laws, you'll see that the focus is on not treating anyone differently. And it wasn't until 1990, when the Americans with Disabilities Act came out, that we saw in civil rights laws an affirmative obligation to, on behalf of an employer, to do something, to afford someone additional rights. And that came in the context of accommodations. But what the case law was pretty clear about is that being pregnant in and of itself was not a disability. A normal pregnancy did not count. And so coverage under the ADA would only come in the context of having a special condition related to your pregnancy that counted as a disability. So if a pregnant person developed a condition that would qualify as a disability, those could include preeclampsia, gestational diabetes, sciatica. Any of those would, because of it counting as a disability, would require the employer to accommodate under the ADA. But for those women who did not qualify to have a disability and are just needing accommodations for a normal pregnancy, that wasn't covered. Congress recognized that this was a problem back in 2012 and introduced a bill called the Pregnant Woman Fairness Act. And for the next 11 years, it could not get passed. And so we'll talk a little bit more about that later. And so Alma's going to talk about Washington and what we did to cover that.
Hello. I hope you guys can hear me well. Yeah, I'm Alma. Thank you for being here and listening to our presentation. This is the law. We're mostly here to talk about the Healthy Starts Act. It was enacted in 2017 when Washington State decided to provide pregnant workers greater protections that the federal laws and other state laws have given them. It clarifies employers' affirmative obligations to provide pregnancy accommodations. And the legislature tasked the Attorney General's office with investigating and enforcing these protections for pregnant employees in the state of Washington. So that's why we in the civil rights divisions are the ones that are enforcing this law. The law applies to employers that have at least 15 employees. Specifically, we nevertheless encourage employees to contact us even if their employer has less than 15 employees because of the other laws that Terry had mentioned that can apply to employers of 8 employees or more. So we can work with the employee and their employers to find a solution, even if the Healthy Starts Act wouldn't apply to them directly. Next slide, please. So the law states protections that apply to pregnancy and health-related conditions, and they apply during the pregnancy, and they also apply after the birth of the baby when there are needs for breastfeeding or expressing milk that the employee has to while they're working. Next slide. There are 2 types of accommodations according to this law. There are required accommodations and additional accommodations. The required ones are the ones that employer may not make any exception to comply with. They cannot ask for written certification from a healthcare professional, so they have to provide this accommodation regardless of any hardships that they think they have to be able to provide it to the employee. And then there are additional accommodations that usually employers are required to accommodate unless they can prove that it will have a significant difficulty or expense to them. That's the concept that in law is called the undue burden. And I think Terry will go into more detail in further slides about how the case law interpreted undue burden for businesses and employers in general. And for this additional type of accommodation, the employer can ask for a doctor's note to justify the need to accommodate the employee in this way. Can go to the next slide. So the required accommodations, the ones that need to be accommodated without any type of exception being able to be argued by the business, are frequent and longer or flexible restroom breaks, modifying a no food or drink policy. Next slide. Providing sit more frequently, and the need to not having to lift more than 17 pounds. So these are the most frequent required accommodations that employers will refuse to provide, and we receive complaints about from the workers. The required bathroom breaks, modifying their policy regarding food, being able to have food and drinks at work, the ability to sit more frequently, and not having to lift over 17 pounds. Some examples of complaints we've received related to these accommodations are frequently from restaurants worker. That's a frequent place where we see this type of issues. Waiters, for example, that are denied the required breaks to be able to use the bathroom or to sit, to have a break from their shifts, or being able to drink or eat when they need to during their work shifts. Another frequent accommodation that we receive complaints about a lot is not having to lift over 17 pounds. As you'll be able to see throughout the slides and the cases we will provide, most times in the complaints that we see is not that the employer cannot really accommodate. Most of the times they either don't know the obligations that they have or don't want to find a solution or are not creative enough to be able to bring up solutions. So in many of these complaints, what our attorneys do is work with the employer to find a way to accommodate the employee. For example, we had a case of a hotel receptionist that was pregnant, and during her shift, she received the delivery of food, and meals for breakfast for the hotel. And it was several heavy boxes that she needed to lift and take to the kitchen. And when she became pregnant, she didn't want to do this anymore. Her boss said, who is going to receive these boxes if it's not you? You're there in the lobby, you're the only person in the hotel, because it was a small hotel that could receive them. So the solution that we came up with is the delivery time of the boxes was just switched to the shift of another receptionist that was not pregnant and could do the lifting. A lot of these type of complaints, unfortunately, come from employees of healthcare facilities. We've received, for example, complaints from workers in radiology and clinics. For example, there was one worker in a radiology clinic that was tasked with pushing patients in wheelchairs, helping them to the machine, and that got too heavy for her when she was pregnant. So we worked with that facility to find another worker of the facility that could help her out. It was a fairly small clinic, so they had to rearrange a little the work of their employees to be able to find this help. But as it is a required accommodation, the employer could not deny this accommodation for the worker. Next slide, please. And then we have the additional accommodations. These are the ones where the employer usually needs to provide them unless they can prove that it represents a significant difficulty or expense to them. They may require a doctor's note to justify the need of the accommodation. These accommodations are requesting job restructuring, including modifying a work schedule, job reassignment, changing a work station, or providing equipment for the worker. The request of provide a temporary transfer to a less strenuous or hazardous position. Scheduling flexibility for prenatal visits, and any further accommodations that the employee may need. So we have had cases of this type of requests. There was, for example, a woman that worked at a homeless shelter that was located in quite a dangerous area. She was receiving threats at work from a person that she had dealt with that was mentally unstable and was threatening her. There were quite hard threats of stabbing her belly, statements like that this person had made. So the worker was suffering of anxiety because of these threats. So while she was pregnant, she was moved to another location of the organization that was safer for her, and it helped her feel safer during during her pregnancy. There have been workers that complained that their work was not flexible enough with the prenatal visits they were required. This happens frequently, especially if the pregnant person is having health complications related to the pregnancy. We've seen workers that required more prenatal visits than usual, than a person with no complications would have. And she was having emergency visits and was being penalized by her work for not being on time. So we worked with the employer to understand that this visit, they should be flexible with these visits, and the penalizations that the employee received were taken away. And additional accommodations can be really any further accommodations the employee may need. For example, we had an employee that was having trouble with uniform requirements from her work while she was pregnant. The type of pants that the work was requiring were challenging for her to wear during her pregnancy, and she was being penalized for not using the appropriate uniform. So after talking with their employer, allowed her to wear yoga pants that were kind of similar, but still more comfortable for her during her pregnancy instead of the uniform. Like I mentioned, it is many times our job to work with the employers and find a solution that they might not seen or might not work hard enough to find a solution to accommodate the pregnant employee. And one thing that we want to mention is that the requirement to provide written medical certification that these additional accommodations can require according to the law cannot be read as permission for the employer to call the employee's doctor. So something that our attorneys have seen many times is that because these accommodations, the employer may ask for a doctor's note, they many times try to contact or ask the employee to give them their doctor's numbers so they can talk to them and work through the the medical requirements that this person has been given, to see if they can be given permission to lift a higher load, or anything that will make it easier for them to keep working with the pregnant employee. And we just want to say that this is not what the law has intended. There's no, the employee is not obligated to provide contact with the doctor, and the doctor, it's not the intention of the law that the doctors have to talk to the worker and have to deal with the accommodations that the employee needs. Can go to the next slide. This accommodation was initially included as an additional accommodation with all the requirements of the other ones, of doctor's notes, and not representing undue burden for the employer. Terry will talk in the next slide of the amendment that the law has had, and how now employers are not allowed to request a doctor's note to provide this accommodation. This accommodation is the one that the employer is obligated to provide reasonable break time for an employee to express breast milk for up to 2 years after the child's birth. Each time the employee has need to express the milk, and provide in a private location other than a bathroom, if such location exists at the place of business or work site, which may be used by the employee to express breast milk. If the business location does not have a space for the employee to express milk, the employer shall work with the employee to identify a convenient location and work schedule to accommodate their needs. We have to pay attention here of why the word reasonable was used in the law. The concept of reasonableness, according to the law, means that main priority is what the woman needs. She knows what her body needs and the nature of the job that she's doing, and if this job will allow her to continue doing it. The employer needs to hear to her request and what she specifically needs for her specific situation to be able to express milk or breastfeed while working. We have heard of many complaints about the employer not providing a location that is private or sanitary enough to express milk. Employees have been given access to gym lockers, bathrooms, frequently places that were not sanitary enough, or where other employees would come and interrupt, or places that would not lock properly. So those are not appropriate places to provide for the employee to express milk. They cannot penalize or suspend employees for tardiness related to the need to express milk. We've seen cases of employees that, because of certain health issues, or infections they were having to take longer pump breaks, and they were being penalized because their bosses didn't understand. They've seen other employees that require less time to express milk, so they didn't understand why this specific employee was taking longer. But it just depended on the specific situation of that employee, and that is something that employers sometimes have a hard time understanding. We can go to the next slide. I think it's back to you, Terry. We can't hear you.
Sorry, I was on mute accidentally. So Alma touched on this briefly. What happened is originally breastfeeding was required to have a doctor's note. I'm sure you all can imagine how sort of ridiculous that could be if you needed to have to go to your doctor to get a note. So in 2020, in the legislative session in Washington, they changed that law to require this of employers, unless there is a situation where an employer could show an undue hardship. No need to go to your doctor for a note for this anymore. It falls under the sections of additional accommodations, but without the ability to for the employer to require an employee to go and get their doctor's note. And like the other accommodations that fall under the additional, and you'll have these slides, so you'll know, like, you know, there's a category of accommodations under this act where an employer must provide it. There is no excuse for that. And then these additional accommodations are required unless the employer can show an undue hardship for denying the accommodation. And like it says on the slide, there's not any bright line rule on what constitutes an undue hardship, but what the law does tell us is that the employer must consider the cost or difficulty of the accommodation in comparison to the employer's resources available. So if you are a really small business that has maybe 15 employees, and it would be a huge struggle to provide a certain type of accommodation, the court will take that into account. On the other hand, if you're a large employer, say, you know, Amazon or Walmart or one of the bigger employers, then you can pretty much, it would be difficult for those employers to show that providing an accommodation to an employee would have a detrimental impact on their business. And so that's going to be the only situation where employers might find themselves having an appropriate reason not to provide the reasonable accommodation. But like Alma was talking about, there are many circumstances that with some creative thought, the employer can accommodate folks by just being a little bit more creative. And so that's part of the process, is exploring how might we be able to do this. It's very fact dependent when the courts are looking at undue hardship, and you know, reasonable in the context of the resources available to the employer's size, and other things like that. So let's see, accommodation cases that we've encountered before. We had a retail employer that had a no food or drink policy. And the person needed to have frequent meal breaks, and asking the employer just to allow this person to break that policy. The detrimental effect to the employer really wasn't any at all. But maybe if it was a situation where they didn't want this person eating at the cash register or something like that, you know, being creative and saying, okay, like, she can go in the other room, or just, you know, pop a snack into her mouth when she's in between customers, something like that. Okay, sorry. So one of the biggest worries that we have when pregnant employees ask about accommodations is whether in asking for these accommodations or asserting their rights under this act, will the employer retaliate against them or punish them or do something else? And the act explicitly prohibits employers from taking any action against the employee for asking for the accommodations that are covered here. So no retaliation, no punishment, no denying the employee of other opportunities. We had another case that came into our office where a employee was hired as a supervisor. When she asked for an accommodation under the act of not lifting over 20 pounds, what the employer said to her, she revealed that she was pregnant. Oh, well, I didn't realize that you were pregnant. Since you're going to be going on leave, we've changed our minds, and it's not worth the effort to get you into the position of supervisor anymore, since you're going to be leaving soon. And that would be an example of retaliation under the act. Employee asserts their rights and then is not promoted as they were going to be because of A, the revelation that they were pregnant, and B, because they asked for accommodations under the act. One thing we also see occasionally is an employer, instead of making an accommodation, may want to have an employee just be off work until their pregnancy and maternity leave is over. And that is another thing that the act does not envision. So if there are alternatives that can be provided by the employer, you must exhaust those before placing an employee on leave. And this is particularly important for individuals who want to, save the leave that's available to them until after they have the baby. So even though you may not be able to lift, you need frequent breaks, you're still able to work in many other respects if you get these small accommodations. So making a pregnant employee take leave early so that the employer doesn't have to make changes to the job is not okay. Just briefly, I wanted to mention that the converse of that is also true. An employer cannot impose quote unquote accommodations or differences in employees' work if they don't ask for them. When I was at the EEOC, we litigated a case where the woman was a security guard, and she wanted to work at a particular location, and the employer said, in their opinion, that location really wasn't good for pregnant women to be at. When we deposed them, we asked, why is it that you say that this is not a place where pregnant women should be? And what the supervisor said was, well, when my wife was pregnant, she was really unstable on her feet, and there's a lot of gravel at this location, and it might be, unstable for her to be walking around. And so that's an example of an employer sort of imposing their opinions about it. But if the pregnant woman isn't asking for an accommodation, the employer really cannot make assumptions based on stereotypes about the capability of that particular person to perform the job. So I want to talk just briefly about the Fair Labor Standards Act. It was amended in 2020 in connection with the Affordable Care Act. So in addition to the Washington state law that we have, the Affordable Care Act also gives nursing employees the right to have break times and to have a place other than a bathroom to pump. The employer is required to have a space for the employee where they won't be interrupted by coworkers, won't be interrupted by the public while they're work. And unlike Washington law, which is 2 years after the child is born, the federal law covers 1 year after the birth. So again, we're seeing that Washington law is a little bit more progressive than what we're seeing at the federal level. One thing I wanted to add about the breaks is when an employer provides time for an employee to take a break, those breaks are not required to be paid, but there's a big caveat to that, and that is it would be discrimination to provide other employees paid break times that are compensated and not provide that same benefit to pregnant employees. So for example, if the employer provides 2 15-minute paid breaks to their employees, then they must do so for the pregnant woman as well. And another caveat to that that you can have patients think about is if an employee is able to perform work while they're pumping, they also have the right to be paid. And at least, you know, in our job, many times we are in our office in front of the computer. So we could be answering voicemails, we could be answering emails, doing drafting of legal papers at the same time that you're pumping. And so if an employee does not have a completely work-free break, they must be compensated for that as well. Okay, so what I said before was we'd come back to the Pregnancy Worker Fairness Act. Remember, Congress introduced it back in 2012, and it's just been kicked around by the legislature. I think they heard it every single year since 2012. And at the very end of the calendar year of 2022, the act finally passed as part of the omnibus spending bill. It hasn't gone into effect yet. It will in June of 2023. With this act, Congress extended federal protections for pregnant workers and workers who need lactation breaks. And so this act will sort of parrot what we already have in Washington state, where it requires employers to affirmatively accommodate pregnant workers who don't fit the definition of someone who is disabled. So any known limitation that's related to a pregnancy, childbirth, or any medical related condition is explicitly included in this. And again, must be accommodated unless the employer can show that undue hardship. Like we said, with the Healthy Starts Act, Washington was ahead of the game by providing it 5 years earlier. And in fact, most state laws, I think there's 30 states that already have accommodation for pregnant workers, but this catches the federal laws up. It will be enforced by the Equal Opportunity Commission, who's, I understand, drafting regulations right now. And within the same appropriations bill, again, we saw laws that were enacted for providing pregnant employees nursing breaks and breaks to express milk.
So how do we file a complaint with our office related to pregnancy accommodations? You can either send us an email to this email address provided here in the slides, pregnancy@atg.wa.gov, call toll-free line at 833-660-4877, or submit an online form that you can find in the Attorney General of Washington's webpage. Go to the next slide and see how this webpage looks like. We have here some information related to what the laws say about accommodations, what are the required ones, the additional ones, and so some help for employers and employees to understand their obligations and rights. And you also here have a link that will take you to a form. You can see it in the next slide, how the form looks like, where you'll put the information about the employees and contact information. You can see here that there's a question that says, is this complaint about you? So it gives another person that's not the pregnant worker the option of submitting the complaint on their behalf. So that's an option, but we will need to talk, of course, to the pregnant worker at some point to understand more about the situation. And we can go to the next slide. This is an old picture of our team. We have grown since this picture was taken. We have now an intake coordinator. Her name is Gail, and she's the one responding to online complaints, emails, and voicemails that can relate to the Healthy Starts Act. She's usually the one making the first call to gather more information if we need it, and she'll assign it to an attorney in our division that will contact the complainant. This contact to the complainant will usually happen in the first 24 hours after we receive the complaint. So we're quite diligent and always on the lookout for this type of complaints so we can resolve it when the employee needs it. Most of the complaints we received are resolved without litigation. So the attorney will call the employer and find out what's going on, or if they don't receive a response, they can send a letter requesting the information they need. They usually draft letters asking about the employer's policies related to pregnancy or breastfeeding accommodations, if there has been any penalties or sanctions to the worker, those types of stuff, and have a conversation and try to work in a solution. So I think that's pretty encouraging for people to submit a complaint, knowing that most likely it'd be able to be resolved without having to go to court and be part of a lawsuit or any type of litigation. There's usually an amicable solution. And of course, if there's retaliation against the employee for requesting this accommodation or for contacting us, we'll take action and make sure there's no retaliation against the worker, because that's illegal. And Terry will talk a little bit more about the one case we have where we did have to go to litigation against a company called Colmar for not providing the needed accommodations to an employee. As you will see, it was quite alarming in the way they were not working with us, and we did have to sue them. Go ahead, Terry.
Yeah, so this is the one case. Like Alma said, most of the time employers are willing to work with our office. Sometimes employers don't know or understand what their obligations are. And so there is this process where we're trying to assist the pregnant worker with being able to continue working. That's the best case scenario. One other thing I will say is we have seen some employers be sort of repeat offenders of this law. And when that happens, what our office will do is, if we see a violation, then we had to take care of it, a violation, we had to take care of it, and it keeps happening, we will open a broader investigation and ask for policies and records by the employer in order to understand why this keeps happening. So, to the Colmar case. This case was filed against FedEx. Colmar is a contractor of FedEx, and it was on the basis that the company had fired a pregnant employee immediately after she had requested the legally required accommodations. So how the case played out was the employee sent her employer a text message asking if she could avoid lifting the really heavy items for the next few days on her route. And the director responded asking, well, why do you need that? And the employee was pregnant and let her employer know that, and also provided that her physician had told her, because I think she was cramping or something, not to lift heavy items at this stage of her pregnancy, which was pretty early on, and they were afraid of miscarriage. The employer or the employee offered, I can get a doctor's note if you need that, but was told, nope, we don't need that, but just go ahead and bring in your work van, because we're going to be giving the route to somebody else who can lift. And then texted the employee and said, well, I was going to have to let you go anyhow, eventually. So, go ahead and come in, and basically you can't be employed with us anymore. It was something that was particularly impactful for this worker. She was the sole earner for her family. And she ended up having to move from where they were living. They had to live with relatives that were in a different part of the state. And the judge in the case awarded this plaintiff $41,000 in penalties and damages for the employer's sort of crass action here. And I wanted to just show you some of the text messages. So it says, here, if you can't do the job, which requires you to lift up to 150 pounds, basically, you're fired. So you'll see here where she says, you know, other people are being accommodated. And the supervisor responds that don't give me that crap, that you can't work because you're pregnant or you don't want to. It doesn't matter anymore because you're no longer employed. So not exactly what we want to see in terms of working with the employee for a reasonable accommodation. So we'd like to just open it up for questions if anyone has any, and anything else, you know, that we can provide to be helpful.
Thank you guys very much. I noticed on the online complaint form, and that, as you guys have stated, anyone can fill that out. So any of the MSS or ICM providers can fill it out. And I did see that there was a box of what language that the pregnant person speaks. So is there any limitation as to which language, or you guys use an interpreter service that's pretty broad and can do most languages?
Yeah.
Oh, go ahead, Alma.
Oh, sorry. Yeah. So we have folks in our division that speak Spanish. If the required language is Spanish, we have attorneys that speak Spanish, or investigators. I speak Spanish. So we'll contact the employee. If it's any other language, we'll most likely use service over the phone. It's a company that will have an interpreter for us on the phone translating. And I don't think there should be limitations on the language. I believe we should have an interpreter available for whatever language they need.
Great, thanks. So we do have some questions coming in. I do see somebody said that the chat was disabled. So any questions, please submit them in the Q&A field. I did put in the chat the presentation, the Healthy Starts Act presentation, and then the First Steps presentation as well, which will be included on the email when we send out a link. So again, any questions, use the Q&A box. So one question that came in is, will you be making presentations to business associations or other regional/community groups?
Yeah, I think we're happy to present to anyone. I don't know that we have anything set in the books to make presentations to business associations right now, but we're certainly open to that. It's something that a group who's interested in having us speak about this could contact the Attorney General's office.
Great. And how long do people have to file a complaint?
I don't think there's a time limit. Is there, Alma?
I don't think so. To file a complaint with us, certainly there's not. I don't know if it's a statute of limitations regarding to the law, but I would think if someone needs an accommodation, it's limited to the 9 months or 2 years, so that wouldn't be affected.
Yeah, I mean, part of what's envisioned in this act is to provide that accommodation to an employee. So if an employee, like for example, with the FedEx was terminated or something in violation of the act, we would want to know that right away. I think it would be a lot more difficult for the employee to argue a year later that wasn't acceptable to them, you know, if they didn't complain about it or take action about it right away. So really, you know, if folks are having difficulty at work, the employer's not providing the appropriate accommodations, I would encourage that employee to, you know, complain to their employer, but also let us know right away.
Great, thanks. A couple questions in regards to the 17-pound requirement. The first says that one of the slides says required accommodations. Does that mean no doctor's note required for lifting requirements? And where does the 17-pound requirement come from? And then there's another that's kind of with the 17. I'm slightly confused on the no lifting over 17 pounds. And if a worker has a note that their limit is 25 pounds, do we go with the doctor's note?
So if the accommodation is in the list of those required accommodation, that means that the employer needs to accommodate and they cannot ask for a doctor's note. So if the employee asks for it, they have to accommodate. No need to present or talk to a doctor or anything. I'm not sure where the 17th comes from. Do you know anything about that, Terry?
I don't actually, so I'm fairly new to our office and this law. So unfortunately, I don't have the answer to that, but we can certainly look that up and figure out where the origin of the 17 pounds comes from.
Okay, thanks.
It says that if a worker has a note that their limit is 25 pounds, do we go with the doctor's note? So it's up to what the employee is requesting. So the law says over 17 pounds. If they don't want to lift over 17 pounds, they shouldn't be made to. If the employee says that they can lift up to 25 pounds and they cannot lift more than that because that's what the doctors told them, that's what the employer should do, not have them lift over 25 pounds. It's always up to what the employee wants and what their doctor is saying. The employer cannot force the employee to take accommodations that they're not requesting. If the employee is fine with lifting up to 25 pounds, then that's what they're requesting. The company shouldn't force them to not lift from 17 up because that's what the law says.
Yeah. So one thing just about that question, it sounds like it's posed from maybe the employer's perspective. So, if the note says 25, which accommodation do you go with if the employee is saying, I don't want to lift more than 17 pounds? And so something you should keep in mind is that the lifting requirements fall under, sorry, my phone is going off. The lifting requirements fall under the required category, meaning that a doctor's note is not required for them. And so if an employee says, I don't want to lift more than 17 pounds, they don't actually need, doctor confirmation of that requirement because it's automatic under the Washington law.
Thanks. Another question is there any restriction on employees who are able to access these services or have accommodations? For example, employees paid under the table or people working without legal worker status in the UN?
No limits, no. Anyone can call us.
Mm-hmm. Yeah, and in particular, the discrimination laws do cover folks who may not have legal worker status in the United States. So that is not a condition to our enforcement of civil rights laws in the Civil Rights Division, just so you know.
And another question is, does pumping time count as paid work time? For example, in an 8-hour shift, the employee requests 2 or 3 total hours to pump. Is that included in the 8-hour shift? Is this time able to be in addition to normal lunch/break times?
So the employee has an 8-hour shift and they're pumping for 3 hours. Is that what we're talking about?
Yeah, total if they have more.
Yeah. Yeah, if it's total time, what The law does not require employers to pay for all of the break time. So what that would mean is if an employee is entitled to two paid 15-minute breaks for 8-hour shift, and I think that's what the law requires employers to pay, then they should be paid for that time regardless of when the employee needs to take it. However, if the employer is not providing additional time for employees to take breaks that are paid in other situations, I think the employer would have an argument that they don't need to pay for the additional time that an employee needs to take to pump.
Like 2 more questions. Are there any other penalties aside from litigation to employers who violate these legal protections?
That really is how we penalize employers, is by filing litigation or actions against them. So that's the remedy that these accommodation statutes provide, is should the employer violate the law, the employee is entitled to remedies in that way. Like we've talked about, this office really hasn't had to file a lawsuit other than just that one that we mentioned. So what that means is that the employer was able to provide the accommodation to the employee. They got back to work. Should there be a situation that isn't rectifiable, I think that our office can in fact engage in sort of a conciliation or settlement type negotiation with the employer if damages are at issue. And so we may be able to do some sort of an agreement for compensation even before filing a lawsuit.
Okay. And last question, and if more questions come in, are you guys okay if Shalia and I send them your way for our FAQ, the presentation? Perfect.
Yeah.
Thanks. All right, so last question is, can employers make people use their personal time off for their OB appointments instead of making up the hours for that day, or claim leave without pay?
I think the OB appointments would be handled in the same way that you would handle any other sort of doctor's appointment or, childcare issue that came up, or, emergency. Any time an employee needs to leave, I think there has to be some way for them to be able to take that time. So it's not going to be a paid time away from work, if that's what the question is asking. It would probably depend on the employer's policy on whether or not those hours could be made up at a different time. And it's probably dependent on the type of job that the pregnant employee had. But there's no mechanism in the law that says that employees would be able to make up time for OB appointments later instead of taking leave.
Great. That's the last of the questions. I appreciate your guys' time so much, and just I learned a lot. My mind's kind of blown, and I appreciate all the work that you guys do and the support that you give the pregnant people of Washington to be vocal and speak up. So thank you very, very much. And if we have any further questions, if anybody has additional questions, you can always email myself, Heather, or Shalia, and we can send the questions on to Terry and Alma. So
yeah. Thank you, Heather. We appreciate the invitation and the opportunity to be here. And also, like, if people have questions, can also email the pregnancy accommodations email address that we provided in this presentation, or even submit a complaint. Like, we receive sometimes just questions that people want to know what to do in a situation before complaining, they can probably receive an answer as well.
Great, thank you. All right, so I can't remember if it's Terry. I think Terry, you might be sharing, so
Yeah.
turn that off and then I'll try to get mine going. Maybe.
Okay.
All
Thank
right.
you all.
Thank you, guys. Okay, and hopefully you guys are now seeing my screen. So some program updates and reminders. We just have about 19 minutes. So if I talk a little too fast, please let me know and I'll try to slow down. And then if I don't get a chance to answer questions again, we will do an FAQ to answer any questions that I couldn't get to. So first, I just want to, some Gov Delivery messages have been going out. So if you are on our Gov Delivery First Steps MSS, ICM, and Billing MSS and ICM, I think it is, topics, you should have at least gotten one update in regards to the April 1st changes, or not really changes, but HCA has, clients will receive a renewal notice prior to the end of their renewal period sometime over the next 12 months. So based on the renewal date. And it's really important to make sure that you encourage your clients to update their contact information, especially their mailing address, so that when notices go out, they receive them. One thing when I do the monthly client list, that I'll notice that the residential address is updated a lot of times, and the mailing address has not been, and it's a mailing address that was first put in the system, say back in 2014 or something. So make sure that your clients that you're working with update any information that they need to in the health plan finder, and definitely encourage that they also make sure that their mailing address is accurate, so that when letters come out, that they receive them. I've also included here a link to the changes to the Apple Health continued coverage website that talks a little bit about how we're going back to normal operations April 1st, and it'll be a process. But then also on the website, and I think I'm going to open it. Here we go. On the website, it has kind of what to expect, and it also has how can clients update their client contact information. So the website on the PowerPoint or the PDF that you'll get in the email or was attached into the comments section has a link to this website that talks a little bit about the continued coverage. Also wanted to let you guys know of some legislative updates. There have been these ones here that I've listed on the website, excuse me, on the slide, are maternity related bills that have dropped so far this legislative session. The first one is kind of, whoops, a big one that I want to bring to your attention. And this is Senate Bill 5580. If you look at the bill, which I won't go into, but the bill has a few new sections. The first section is it directs the HCA, Healthcare Authority, to create a post-delivery program for people with substance use disorder at the time of delivery, allowing for extended post-delivery hospital care. The second section, excuse me, requires Healthcare Authority to update MSS to address perinatal outcomes and increase equity and healthier birth outcomes by updating the current screening tools, ensure care coordination, which includes sharing the screening tools with the patient's healthcare provider, develop a mechanism to collect the screening results, evaluate the program, and increase utilization. The third new section within the bill is to increase the federal poverty level for pregnant and postpartum people from 193% to 210%. So on the slide, I have a hyperlink that'll take you to this page. If you're interested and want to keep updated on the Senate Bill 5580, the best thing to do is on this page, click the Get Email Notifications. And what that will do is anything that takes place with this bill, if there's a hearing or a substitute been made. So far there's been one, and that when the bill was originally dropped, they had the postpartum SUD and the MSS changes to be done by January 1st, 2024, which we know that it's too soon. We wouldn't be able to get everything done by then. So we've asked to have it to 2025. So any information that happens with this bill, you'll get email notifications. So this is a good way to keep updated on the bill. So another one is Senate Bill 5501, which requires the Healthcare Authority to establish a Count the Kicks program that focuses on preventing stillbirths and adopt a platform for recording and tracking fetal movements. It also directs Department of Health to design, prepare, and make available online materials to inform providers about evidence-based research and practices to reduce stillbirth. The other bills, there's a Senate Bill 1168 or House Bill 1168, and that is, excuse me, expands the scope of the fetal alcohol exposure interagency agreement to include prenatal substances other than alcohol and adds that DCYF as a party to the agreement. The bill requires Healthcare Authority to convene meetings with specified stakeholders and submit recommendations to the legislature on ways to increase access to diagnosis, treatment, services, and supports for children who are exposed to substances before birth and their families and caregivers. The other bill is Senate Bill 5470, and that is, it creates a voluntary certification process for lactation consultants through the Department of Health. And then it also directs the Healthcare Authority to ensure that the services for certified lactation consultants are covered under Medicaid. So those are 4 bills that are currently going through the process of the legislative process that are related specific to maternal services and programs. The next is about community health worker grants. It's an update. I think we might have spoke about it at a prior webinar, and I just wanted to let you know that the awardees have been chosen, and the website that's on the link on the slide will take you to this website. It lists out who the awardees are. And the reason why I wanted to just point this out is because these community health workers through this grant are separate from maternity support services, from MSS and ICM. It's a grant where they have specific services that they will be providing, which is not MSS or ICM. And we know that clients can sometimes get confused because there are so many different things happening in a lot of different programs. So this is just kind of my way of reminding everyone that before you see a client, and even sometimes as you're seeing someone, to submit service limit checks. And the document will be attached to the email for the webinar on how to do that. And that's where you're going to submit a request through the Healthcare Authority's secure online form to verify if a client may have a paid MSS or ICM claim in the system. So there are some limitations. It's only going to show if there's been a paid claim, but it's a way to verify that, just to kind of double check and see if somebody's receiving MSS or ICM services at another location outside of your location. And I just wanted to point out with the community health workers, we allow community health workers or community health representatives in MSS. So those through the grant, completely separate, different, the way that the billing is different. So if you hear that somebody's seen a community health worker and you do a service limit check and see that it's an MSS procedure code was billed, then that's going to be through the MSS program. And then I also wanted to do a reminder for coordinators who may be listening that I do continue to send out a monthly list of newly identified pregnant and postpartum people every month. So if your agency is not receiving the list and would like to, please reach out to me, Heather. As a reminder, DSHS used to send out the monthly list, but that contract was ended in December 2014. So MSS agencies should not be receiving a list from DSHS or any other entity. And if you are receiving a list from someone else, that's not me, please contact me right away. I kind of need to be aware of that. So if you want to receive the list, email me, the coordinators that are listening, or if you're getting it from someone else, please let me know right away. You can call me or send me an email. Now I'm going to check to see if there are any questions. Don't see any questions yet, but I did have some questions at the beginning that were related to MSS and ICM, so I will answer those now. The first is that, are we able to provide services to families who both have a pregnant and infant eligible for first steps? Or do we need to terminate infant and ICM to provide services for the pregnant person who is now pregnant? So that it used to be a few years ago that if someone whose infant was receiving ICM became pregnant again, that ICM had to end and then MSS start, but that language was removed a few years ago. So infants are eligible for ICM no matter if their parent becomes pregnant before their first birthday or not. Just need to make sure that you're not duplicating those services, that you're keeping ICM separate from the MSS. Another question is, how long will MSS and ICM providers be able to conduct televisits? And as I've been saying in past webinars, the Washington State legislators passed a bill last year, the year before, that telehealth services are an allowable Medicaid covered service. So telehealth is, I don't see an end date. There's no end date, so we will be allowing the telehealth audio only visits. There may be some rules in regards to that first visit. The initial visits may need to be face-to-face in person, or possibly telemedicine, that audio-visual HIPAA compliant platform. That part we're still going to need to discuss and meet with stakeholders and have a work group to talk about those, what would need to be required. But as of right now, continue as we have been. And when things need to be changed, I will be sending out an email to the coordinators, to see MSS and ICM coordinators, to see who may be interested in being part of a work group to kind of determine the policy around the audio only visits and how many may need to be in person, face-to-face, or do we allow most all? I think the way that the bill was written, and I think it's in 2024, there is a definition in regards to the initial visit. So more will come in regards to that. Right. Checking. Oh, and then the other question that came through was the same about the audio only, if it's still allowed, and it is, and it will continue to be an allowable visit. Those were kind of the updates that we had. I think the main one to kind of keep watch of is that Senate Bill 5580, which has the language that's included, and I'll bring it up now since I do have some time. I just wanted to make sure I got through everything. But you'll see here that in section 2 of the bill, it's all about MSS and increasing utilization and updating the provider tools, and coming up with a mechanism that I think we may work to get the screening tools hopefully online, so that everybody has them right there, all the same thing, and then we can see the results, so that we kind of get a good look as to what the landscape looks like, and then also to be able to evaluate the program. And I hope you guys are hearing me okay. It's downpour right now. I can hear outside. It's kind of loud. If you have any questions, about the webinar or any other questions, you can always email Shalia and myself at thefirststeps@hca.wa.gov email, or if you have our emails, you can always email us directly. Our next webinar, I believe, is in April. We're going to get back on schedule. Sorry that we're a month behind with the holidays and everything. Things kind of got a little delayed, but I believe Shalia already has an idea on who our speaker is going to be for April. I remember it's Department of Health, but I cannot remember the topic, but that is definitely going to be in April, and she will be sending out a Gov delivery message with a link to sign up. And again, please encourage anybody to sign up for the webinars. Those who aren't able to attend will still get an email with the link to the webinar. We send it to our IT department and they put it onto YouTube, and so that way we can send out the link to all who attend. So please encourage anyone who is interested, even if they can't attend on that day, to still sign up. I did just get another question regarding the limitation extension requests. Will we be able to process them online now? Yes, please send them online. I've noticed some have sent them online through Provider One, which was the last webinar. And if you need a link to that recording, please let me know. I encourage you to submit them through Provider One directly. I'm still getting some where they're being faxed in and I'm not getting the full fax, or they're not actually making it into the system. So I strongly encourage that you submit them directly into the Provider One system. And again, if you need that link to the last webinar with directions on how, or just the slides, please reach out to me and let me know. All right, I don't see any other questions coming through, so I really appreciate you guys being here. And I really hope that you have a fabulous day and that the wind didn't cause too much issues for those of us that were in the windy areas. Thankfully, my power went out for just a brief moment last night. So have a wonderful day and the rest of the week, and we will talk to you later. Thank you.